Welcome, everyone. A very warm welcome on this very warm afternoon to our LOC webinar on managing employee exits with confidence, part two. Just give everyone some moments to settle in and join the virtual room. This is the second of our two-part series, building on the foundations we discussed in part one, which hopefully many of you attended. And today we're looking at senior exits and the complexities that are associated with those. Today's webinar is again brought to you in partnership with Diversity HR, an established independent recruitment consultancy supporting organisations across London and the South East. Known for their exceptional track record in HR recruitment, the organisation consistently places high quality candidates in a wide range of human resources roles. So, with a comprehensive, discreet, and cost effective approach, Diversity HR operates as an extension of each client's in house team. And they identify candidates who truly fit their requirements. So, thank you to Diversity HR for partnering with us today. Just quickly, in terms of housekeeping, you'll see you have joined on mute. We'd ask that you remain that way, please, during the webinar. We expect the webinar to last 50 minutes to 1 hour, and that will include a Q&A session at the end. To that end, we do have a Q&A chat function. We invite you to post your questions there. You'll just see that at the bottom of your screen, and we will touch on those at the end. If there are any technical issues during the webinar, if you drop out, please just rejoin. We'll keep an eye on the waiting room and let you back in. Once again, we'll be using a Zoom poll to interact with you, as some live interaction is great. So please do join in with responding to the poll and we'll get some real-time feedback. And so with that, let's make a start as we've got lots to get through today. So with me today is the fantastic Alice Aldridge and Emily Waterhouse.
Thank you, Lauren. Yes, hi everyone, I'm Alice Aldridge. I'm a solicitor and partner at LOC. I've worked for LOC for coming up to 7 years now, and I specialise in all aspects of employment law, from non-contentious work, including drafting and negotiating senior level employment contracts, to contentious disputes in the courts and tribunals, as well as acting for employers. I also regularly act for senior employees.
Hi all, I'm Emily. I joined LOC only about 2 months ago, but I'm here to head up the corporate and commercial team, which means I spend most of my time helping businesses navigate the exciting parts of growth, investment, and occasionally the slightly more delicate conversations when senior people move on.
Thanks both. And I'm Lauren McLaughlin. I'm a solicitor and partner here at LOC. I specialise in all aspects of employment law, from contentious disputes in the courts and tribunals to resolving HR matters internally before they reach that stage. And that often includes thorny issues of exits too. So I'm delighted to be a host today. And a bit about LOC and its service areas. We offer employment law, corporate and commercial law, immigration, dispute resolution, and family services. We hope to connect the dots between leadership, compliance, and people strategy and business growth. Our integrated approach provides commercially focused, pragmatic solutions that help you when you're faced with an issue or a decision that will hopefully protect, grow, or future proof your organization. So, by covering every angle, we aim to give you the confidence to move forward for long term success. So, a one stop shop. So, building directly on part one of this two-part series, we today address the additional considerations which arise with exiting your senior employees, your directors or shareholders, where complexity and exposure can increase sharply. We'll go through a quick recap of part one, the foundations. We'll look at what makes senior exits different to that, protections for the business, the director shareholder complexity when it moves beyond pure employment, decision making, planning timelines, and then your Q&As at the end. And we thought that today we would start with a simple, today to understand how confident you are in dealing with senior exits in your business. There may be fewer instances of this in your business compared with more junior exits. And so managers or business leaders don't always get lots of practical experience to plan for the issues which can rise. Hence why legal advice is always advisable. The stakes are really much higher here. So the question is, how confident are you? And you can see the answers there. Very confident, you've got a good process, somewhat. You're not very confident, it's high risk, it's complex, or unsure. Perhaps you've never had to manage this before. So if you could please submit your answers, that would be fantastic. And if we could see the answers from the Zoom poll, please. Okay, so nobody's very confident. I mean, as expected. Hopefully that's why we're here today. Somewhat confident, that's interesting. You want a clearer framework. So we'd like to run through that clear framework today with you. And there's some of you that have not had to manage this before, which is not unsurprising. Senior exits are, like I said, fewer than perhaps your more standard employee exits. So today, hopefully we provide you with that confidence in managing senior exits clearly. And a quick recap before we move forward at part one. So we looked at the foundations for exiting all staff, and in particular, we touched upon upcoming changes. So there are changes to the unfair dismissal regime coming into effect in January 2027. In short, the qualifying period for an exiting employee to challenge that and bring an unfair dismissal claim reduces from 2 years, which it currently is, to just 6 months. After 6 months of service, all your employees can challenge your dismissal decisions with a potential unfair dismissal claim. In addition, the capped compensation regime will become uncapped. That's very relevant to seniors with higher salaries, bonus shares, and other remuneration schemes. And the commercial risk, therefore, is higher on employers. Currently, there's a cap of 52 weeks' pay or approximately £123,000, whichever is lower. So if you've got senior employees on a high six-figure package, maybe beyond that, the risk may currently be limited in unfair dismissal. That will become abolished, meaning the stakes are higher. It follows from what we talked about last week that a good exit is not just a fast exit. With the risks, the exit needs to be the business objective needs to be clear, the route needs to be appropriate, and your paper trail needs to support that decision. If those foundations are in place, the organisation should be in a much stronger position to resolve the matter commercially and to defend its approach if it is challenged or should ever reach tribunal. So the practical message from part one was, given where we are in June 2026, decisions that you are making now as a business about your recruitment, your probation, performance and conduct will matter when the unfair dismissal changes, the regime changes in just over 6 months' time. You must use the first 6 months of employment actively, set your expectations early, diarise probation reviews, document your concerns, and follow up conversations in writing. Do not let issues drift. So, training your line management on this is critical, as well as getting thorough onboarding processes in place now, psychometric testing, and similar steps. So, preparation was a key phrase we used in part one. Process, meetings, documents, and scripts. And we concluded essentially that you need to get your ducks in a row ahead of an exit decision. Alice will take you through the practicalities around what to do in the first 48 hours of an exit, especially in a senior exit, and how to be prepared ahead of that. And things to do now for all your employees is to review your employment contracts, and in particular your probation periods and wording, review your probationary policies, train your line managers on the management of those periods, and ensure you have robust diary and record management processes. Update your performance and capability policies. These will need to be conducted in full after just 6 months of service. And we recognise that recruitment can be difficult, but by enhancing your onboarding processes to get the right candidate to do the role, this may be a key way to avoid those unfair dismissal situations. So that was a quick run through, and I'm now delighted to pass you over to Alice, who's going to guide us through what makes a senior exit different and the additional complexities we deal with day to day as advisors when exiting those in your management and leadership teams.
Thank you, Lauren. Yes, well, what makes a senior exit different? This is a topic that's becoming increasingly important for employers and HR teams, and this is the legal and commercial risk created by senior exits. When a senior employee leaves, the issue is rarely just resignation and replacement. In practice, a senior departure can create immediate risk around clients, confidential information, team stability, strategy, and reputation. In such cases, the disputes can move very quickly from an internal HR process to urgent High Court litigation. In my part of this webinar, I'll focus on 4 key points. The first is why senior exits create particular risk. Secondly, the legal protections that may be available under English law. Thirdly, whether High Court becomes relevant. And then finally, the practical steps organisations should take before, during, and after a senior exit. Senior exits are more complex because senior employees tend to hold 3 things that matter enormously to a business. They hold relationships, key clients, suppliers, introducers, regulators, or investors. They hold information, pricing, pipeline, strategy, financial performance, product development, and workforce plans. And they hold influence. They can affect whether a team remains stable, whether customers stay loyal, and whether a competitor gets a head start. The risk profile is also changing because, as Lauren mentioned earlier, from the 1st of January 2027, the compensatory award cap for ordinary unfair dismissal claims is due to be abolished. Senior employees and executives have often had limited incentive to bring ordinary unfair dismissal claims because the potential value is constrained by the statutory cap, currently the lower of a year's gross pay and £123,000. But once that cap is removed, compensation will be capable of reflecting the actual and protected loss, subject to the usual principles of mitigation. For higher earners, this means that unfair dismissal claims may become far more commercially significant, and employers should expect greater risk of senior employees pursuing high-value employment tribunal claims alongside, or potentially instead of, High Court or shareholder remedies. This all means that the departure of a senior employee can trigger overlapping employment, commercial, and company law issues all at once. And it's that overlap which makes these cases so sensitive. Protections for the business. From a legal perspective, when a senior employee leaves, there are several areas where an employer can look for protection. The first is the contract of employment. A well-drafted contract will include strong notice provisions, garden leave clauses, confidentiality obligations, intellectual property wording, and post-termination restrictions such as non-compete, non-dealing, and non-solicitation of clients and employees. Employees are also subject to a number of implied duties. These include the duty of fidelity, which is essentially to act honestly towards their employer, obligations not to misuse confidential information, and the duty of trust and confidence. Fiduciary duties. We know that directors owe their company fiduciary duties, but those obligations can, albeit in limited and fact-sensitive circumstances, also extend to senior employees or executives. The label senior isn't enough on its own. The question is whether the individual has undertaken obligations of loyalty, giving rise to fiduciary duties. And then there's urgent relief from the High Court. This is where there's a real risk of misuse of information, solicitation, team moves, or other unlawful competitive advantage. Now, I'm going to start with the employment contract and in particular restrictive covenants because they're often the first thing everyone asks about. Employers, understandably, want to know whether they can stop a senior employee joining a competitor, contacting clients, or taking a team. The answer is sometimes, but only if the clauses in their employment contract have been carefully drafted for the particular role. Under English law, restrictive covenants are presumed unenforceable unless the employer can show that they have a legitimate business interest to protect. The employer then needs to show that the restriction goes no further than is necessary to protect that interest. Typical legitimate interests include confidential information, clients, employees, and workforce stability. As for the reasonableness of the clause, the court will look at factors such as duration, geography, and scope of activities that the clause is restricting. While the courts are not always so strict on this particular point, reasonableness is assessed at the time the contract is entered into, not with hindsight. So restrictive covenants that are generic, copied from other contracts, or left unchanged after a promotion are much more vulnerable. Also, if an employer wants to introduce new restrictions for an employee who is already employed, continued employment alone may not be enough consideration for the restriction to be enforceable, and therefore employers will need to give fresh consideration, such such as a pay rise or other benefits. Non-compete clauses attract the strictest scrutiny from the courts, as they can ultimately prevent a person from being able to earn an income. Even for very senior employees, a non-compete restriction that is longer than 6 months could be vulnerable to challenge. The previous government proposed limiting non-compete restrictions to 3 months. Although that proposal has not and at present changed the law, it reflects the policy scrutiny that non-competes continue to attract. It is therefore imperative that employers make sure that their restrictive covenants are drafted very carefully and tailored to each employee and role. In many senior exit disputes, the strongest claims are not always about non-compete clauses, but are about confidentiality, data extraction, and misuse of information. A business may discover that shortly before departure, an individual forwarded emails to a personal account, downloaded client lists, copied strategic documents, retained contacts, or communicated with colleagues about a coordinated move. Confidentiality obligations in a well-drafted employment contract will survive termination, and the misuse of trade secrets or truly confidential information can justify urgent injunctive relief, even where broader restrictive covenants might be weak. For employers, this means that the evidence trail really matters. Device access, unusual downloads, forwarding activity, messaging patterns, return of property, and certification of deletion all become highly relevant in the first few days after notice is given by a senior employee. Notice periods and garden leave are another critical part of risk management when it comes to a departing senior employee. A properly drafted garden leave clause can be one of the most effective protections available to an employer, because it keeps the employee bound by their ongoing contractual and implied duties while removing them from the business, systems, clients, and the team. During garden leave, the employee remains employed and must continue to receive their pay and contractual benefits. And if there is a valid contractual basis, garden leave can reduce the practical damage that might otherwise occur in the gap before post-termination restrictions begin. Equally, payment in lieu of notice or filing clauses may be attractive where the business just wants a clean break, but that does change the legal position because the contract ends immediately and the organisation loses some of the leverage that ongoing employment provides. Where the departing individual is a director or someone operating at a very senior level, there may be a further layer of protection, fiduciary duties. Directors owe statutory and fiduciary obligations to the company, and those obligations can become central where there's evidence of covert planning, conflicts of interest, diversion of opportunities, or team move activity before resignation and termination. For senior employees who are not directors, fiduciary duties are more fact sensitive and should not be assumed merely because an individual is senior. Employers should not assume that a resignation ends the inquiry. The key question may be what the individual was doing before they left, what they failed to disclose, and whether they used their position to advance a competing venture while still owing duties to the company. Recent High Court team move litigation has again highlighted that senior departures can engage breach of contract, fiduciary duty, inducement, conspiracy, and injunctive relief issues in parallel. Now, that brings me to the High Court. Employers and HR professionals will often be more familiar with employment tribunal claims, but many senior exit disputes are dealt with in the High Court instead. This is particularly the case where the employer wants speed, confidentiality, injunctive relief, and protection against misuse of information or unlawful competition. The High Court may be asked to grant orders to enforce restrictive covenants, prevent solicitation, restrain the use of confidential information, require delivery up of materials, or stop a team move from causing continuing harm. The remedy that often receives particular attention is the springboard injunction. This is designed not to punish past wrongdoing, but to remove an unfair competitive advantage or head start obtained through unlawful conduct. The court will look carefully at whether there is still a continuing advantage to restrain and whether the employer can identify it with precision. It's important to stress, though, that urgent relief is never automatic. Even where an employer feels morally certain that wrongdoing has occurred, the court will require evidence, proportionality, and precision. Employers need to move quickly, but they also need to move carefully. Delay can damage an application. Overclaiming can damage credibility. Weak contractual drafting can undermine the entire case. And where there's been illness, mishandling of garden leave, ambiguity over notice, the position can become even more complicated than employers expect. It should also be noticed that bringing a claim for urgent relief is not an inexpensive exercise. As the High Court is involved, legal teams and counsel or barristers may need to be instructed and will likely have to work quickly and intensively to turn around the claim in time. A successful employer will seek a cost order, but recovery is never guaranteed and will rarely recover all costs incurred. The practical question for employers is therefore not simply whether a claim is legally arguable, but whether the remedy sought is proportionate to the risk and commercially worthwhile. A further point, particularly in senior employee litigation, is reputational damage. Disputes involving executives, directors, or other senior employees may be of interest to the press, especially where the allegations involve discrimination, confidential information, team moves, and misconduct. While the full details of an employment tribunal claim do not become public until the final hearing, once the claim has been issued, the press are able to find out the names of the parties and the type of claim that is being brought, for example, unfair dismissal or discrimination. The employment tribunals also publish a list of hearings each week, which the press are able to view. These include final hearings, but also preliminary interim hearings, which are normally held in private. Only the parties and their representatives are able to attend private hearings, but if there's a public final hearing, anyone can attend. Therefore, once the final hearing has started, the details of the claim become public. The judgment will also be published unless there's a restricting reporting or other privacy order that's been made. In relation to the High Court, even more information is available to the public early on in the proceedings. In the High Court, once a claim has been issued, anyone can access details of the claim number, the parties, and the legal representatives. Once the claim has been served on the defendants and an acknowledgement of service has been filed on the defendants, then the press will be able to access and obtain copies of statements of case. So these are documents like the details of the claim, the defence, counterclaims and replies, and any preliminary judgment or orders made in public. And therefore, the fact of litigation is immediately public, and hearings are generally held in public unless the court orders otherwise. Documents such as witness statements, skeleton arguments and evidence are not automatically public because they've been filed, but will become accessible if they're relied on or referred to in an open court, or if the court grants permission. Employers should therefore assume that once High Court proceedings are contemplated or issued, there's a real prospect of external scrutiny. Press interest can therefore arise not only when a claim reaches a final hearing and a judgment is issued, but also when a claim is issued or listed for a hearing, a preliminary hearing. Employers should therefore think carefully and early about who's authorised to deal with any media inquiry, what can properly be said while proceedings or negotiations are ongoing, and how internal communications with staff are to be controlled. Any public statement should be accurate, measured and consistent with the employer's legal position, confidentiality obligations, data protection duties, and any without prejudice settlement discussions, they should be carefully considered. Employers also need to understand the risks of engaging with the press themselves, speaking to journalists, sharing documents, giving background briefings or posting about the dispute can aggravate confidentiality breaches, undermine settlement discussions, prejudice litigation, damage reputations, and in some cases expose the individual to further claims for disciplinary action. In practice, a senior exit protocol should therefore include a press and communications plan, as well as more obvious legal and IT steps. Director-shareholder complexity. Also on the subject of High Court, there is a risk that employers sometimes overlook where senior employees are involved. This is most relevant in owner-managed businesses, founder-led companies, and other sort of closely held structures. If the senior individual is not just an employee, but also a shareholder or a director shareholder, they could bring an unfair prejudice petition under Section 994 of the Companies Act 2006 against the company. These claims can arise where removal from management, dismissal from an employed role, exclusion from information, dilution of shareholdings, or a reallocation of value may be said to prejudice the individual's interest as a member. The key point is that what looks from an HR perspective like an exit process can also be characterised from the individual's perspective as an exclusion from the business in a way that is unfairly prejudicial to their shareholder interests. Now, these claims are highly fact sensitive, but they're strategically important because they can turn an employment departure into a wider shareholder dispute, often with a buyout remedy in view. Again, as the claim involves the High Court, there's not only the risk to the company of having a judgment against it, but there's also the risk of having to pay some of the former employee's legal costs, which may be significant. Now, priorities for senior exits. If I were to reduce the employer response to a practical framework, I would suggest 6 priorities. First, get the contract right at the outset and review it again on promotion. Restrictions should be tailored to the role, market, client base, and the actual risk. Secondly, know where your confidential information is and who can access it. Thirdly, have a senior exit protocol. Who's informed? Who secures the devices? Who suspends access? Who communicates with clients and staff? And who preserves the evidence? Fourthly, decide quickly whether garden leave, working notice, or pylon best protects the business. Fifthly, investigate calmly and document carefully, rather than relying on assumptions or hearsay. And finally, know when to escalate for urgent legal advice, particularly where there are signs of team movement, data extraction, client contact, or director-level misconduct. Usual red flags include unusual downloads, forwarding documents to personal email, unexplained deletion of messages, reluctance to return devices, changes in client contact patterns, coordinated resignations, approaches to team members before resignation, or a sudden interest in documents outside the employee's usual responsibilities. None of those points proves wrongdoing on their own, but they are signs that the business may need to preserve evidence and take advice quickly. The legal result is shaped by the first 48 hours. This is when access permissions are changed, return of property steps are taken, legal hold decisions are made, key witnesses are identified, and internal communications are controlled. A well-managed exit can reduce the need for litigation. A poorly managed one can create evidence problems, increase employee relations risk, and make urgent court action harder. In some cases, of course, the exit would manage through a settlement agreement, and that can be a useful opportunity to reinforce confidentiality, secure the return and deletion of company property and data, agree internal and external communication, obtain warranties about non-use of information, and where appropriate, reaffirm post-termination restrictions. It's also worth keeping a balanced perspective. Not every senior exit is wrongful. Competition itself is not unlawful, and courts will not enforce restrictions simply to stop employees progressing their careers. Recent High Court commentary in team move cases makes clear that ambitious recruitment or movement in the market is not automatically unlawful. The question is whether the employer can show a real legal wrong, enforceable restrictions, misuse of confidential information, breach of duty, inducement, conspiracy, or continuing unfair advantage. Employers who understand that distinction are in a much stronger position, both commercially and legally. In summary, senior exits are not just an HR event, they're a business protection event. The central risks of loss of relationships, loss of confidential information, and loss of team stability. The legal tools available to employers under English law can be powerful, but only where they've been prepared properly and used proportionately. Carefully drafted contracts, enforceable restrictive covenants, robust confidentiality protections, appropriate use of garden leave, and fast, evidence-based decision-making where urgent relief may be needed. There's one key message to leave with today. It is this: prepare early, act quickly, preserve evidence, and stay proportionate. The best way to manage the legal risks of senior exits is not to wait for the resignation. It's to build the contractual, operational, evidential framework in advance so that when a senior person does leave, the organisation can respond quickly, lawfully, and strategically. Emily, moving to you.
Thanks, Alice. Good afternoon, everyone. Alice is very helpfully focused on the employment law considerations. What I'm going to do now is build on that by focusing on the company law side, in particular, the issues that arise in relation to directorships and share ownership. As many of you will already appreciate from your own experiences, these situations can escalate quickly in terms of both legal risk and commercial sensitivity if they are not handled carefully. This is largely because you are not dealing with a single legal relationship, but instead a combination of overlapping frameworks, each with its own rules, remedies, and potential consequences. A useful way of thinking about this type of situation is what I often call the three hats problem. The individuals you're dealing with are rarely just one thing. Instead, they are typically wearing three distinct hats at the same time. They are an employee, they're a director, and they're a shareholder. Each of those roles exists independently, and each is governed by a different set of rights and obligations. That in itself is not necessarily problematic, but the difficulty arises because those roles do not automatically fall away together. Ending someone's employment does not in itself remove them as a director. Equally, it has no automatic effect on their shareholding. And that's where many businesses come unstuck, because they assume that removing someone from one role entirely then leads to the other roles being terminated. That's not the case. So I turn to directorships first. This is often where the first real complexity arises in these situations. As I mentioned earlier, the key issue is that terminating employment does not automatically remove someone as a director. These are legally separate roles and they need to be dealt with separately. When approaching this, there are three key documents you always need to review together. You've got the Directors' Services Agreement, the company's Articles of Association, and the Shareholders' Agreement, if there is one. Ideally, these documents should align. In practice, they often don't, and that's where difficulties begin. So, one of the first questions to ask is whether the director is contractually obliged to resign if their employment comes to an end. If there is a clear and properly drafted obligation, that can make things much more straightforward. But unfortunately, that's not always the case. Just to bring this to light, we recently acted for a client who wanted to terminate a senior individual's employment and remove him as a director at the same time. Now, on the face of it, that sounds relatively straightforward, but in reality, we had two immediate issues. The first issue was that he was the only director of the company. That meant, as a matter of company law, they couldn't simply remove him without first appointing another director, as a company must have at least one director at all times. But that created a practical problem, because appointing a new director in advance of termination would likely raise suspicion. And in a situation like this, timing and control are critical. If the individual suspects what's coming, there's a real risk that they could take clients, extract confidential information, or otherwise disrupt the business before you've secured the position. So that was the first challenge, a structural issue that created a real practical commercial risk. The second issue was the wording of the service agreement. The agreement did include what at first glance looked like a resignation provision. When you looked at it more closely, it simply wasn't strong enough to give the company the protection it needed. And this is something we see quite often in practice. You will often see wording along the lines in the service agreement, which are on the slide. The director shall, if requested by the company, resign from office as a director of the company upon termination of their employment. Now, on the face of it, that sounds helpful, but it has a number of weaknesses. First, it's drafted as an obligation to resign, rather than giving the company the ability to procure or enforce that resignation automatically. So that means that if the director simply refuses to comply, you are left needing to force the obligation, which takes time and creates uncertainty. Secondly, it is triggered only if requested, which introduces an additional step and potentially ambiguity in timing. And importantly, it does not give the company a power of attorney or any mechanism to effect the resignation on the director's behalf if they don't cooperate. So in practice, this type of clause often gives a false sense of security to the company. So where you don't have a provision in the contract, then there's a fallback, which is the statutory removal under Section 168 of the Companies Act. Now, this requires a special notice to be provided to directors, and it's a 28 days notice. This gives the director the opportunity to make written representations and potentially the ability to address shareholders at the meeting. You have to carefully handle this, so you'll need board minutes, shareholder resolutions, and overall make sure the process is compliant. So while this is a reliable mechanism, it's not a quick one and it's not discreet. So from a practical perspective, The risks during this period are significant. You may have a director who is still legally in office, who still has access to sensitive information, and who may still be involved in day-to-day operations. And that can be highly disruptive and in some cases damaging to the business. So the key takeaways from a directorship perspective is this: you need to ensure your documentation gives you a real control over the resignation process, not just a right in theory. That means clear and enforceable resignation obligations, alignment across the service agreement, articles, and the shareholders agreement, and ideally mechanisms that allow the company to act quickly and decisively if needed. Because if those protections are not in place, removing a director can become a protracted, visible, and highly risk process, particularly where the individual is senior and embedded in the business. So the next area is that we're going to move on to share options. This is an area where issues frequently arise, often because assumptions are made without fully reviewing the underlying documentation. The first step is always to identify what type of option scheme you are dealing with. So whether that's an EMI, a CSOP, or a phantom arrangement, or any others really, but it each brings with it its own set of rules and tax implications. Once that's clear and you've identified what option it is, the next step is to interrogate the detail. Were the options actually granted? So we've had numerous occasions where employees have thought that options have been granted to them, but really it was only kind of them saying, okay, well, we'll look to give them to you in the future. So that didn't create any binding contract. So once you've interrogated that, then you need to look at the scheme rules. Have the shares actually vested? And what do the rules say about what happens on termination? So the distinction between a good leaver and a bad leaver is central to this context. That clarification will determine only whether options vest, not only if they vest or lapse, but also whether the individual has the ability to exercise those options after they leave. While it is often assumed that the options will simply lapse on termination, that is not always the case. Some schemes allow for immediate exercise, others provide a limited window, some permit continued participation in defined circumstances. The key pitfall here is always assuming that the option rights will disappear automatically. In reality, they don't always. And if the scheme rules are not carefully reviewed, you can find yourself in a position where value crystallizes in favour of the departing individual in a way that was neither expected nor intended. So now we'll turn to shares. So the actual shares themselves. This is often where the real commercial tension sits. The starting point is very simple. If the individual owns shares, those shares belong to them. They carry rights, and those rights continue unless they are validly restricted or transferred. Once again, the answer lies in the documentation, specifically the Articles of Association and the Shareholders Agreement. Those documents will dictate what should happen to the shares in an exit and whether there is any obligation on the individual to transfer them. Again, the concept of good leaver and bad leaver appears here. It has significant implications. So it can affect not only whether shares must be transferred, but also the price that is paid. That could range from full market value if they're a good leaver, or to a heavy discounted or nominal value in a bad leaver situation. This naturally brings valuation into focus. Is there a clear valuation mechanism in the documentation? Is it objective? And does it reduce the scope for dispute? If the company intends to buy back the shares from the employee, there are additional factors to consider. So does the company have sufficient distributable reserves? Is the buyback being carried out in accordance with company law requirements? And importantly, is it structured in a tax efficient way? In some cases, the final outcomes may instead be negotiated solutions, an arrangement where the shares are retained but the rights attaching to them are adjusted. So we see all scenarios where clients might keep the shares but their voting rights might be removed. Common pitfalls in this area include poorly drafted legal provisions, unclear or missing valuation mechanisms, and tax issues arising from improperly structured buybacks. So then we move on to restricted covenants. Firstly, I wanted to specify that we're going to be talking about what restricted covenants in a shareholders agreement rather than employment contracts, which is what Alice spoke about previously. This distinction is quite important because it's most senior exits. You're not just dealing with one set of restrictions, you're often dealing with two. On the one hand, you have the employment-based restricted covenants, which sit in the services agreement. And then on the other hand, you have the directors' shareholder covenants, which are typically found in the shareholders' agreement, or even sometimes in the articles. What really matters is that these two regimes are treated very differently by the courts. Employment covenants tend to be viewed through the lens of an imbalance of bargaining power. So the employer has imposed those restrictions on an employee. As a result, they are scrutinised quite closely, as Alex mentioned, and need to be tightly drafted to be enforceable. But by contrast, shareholder covenants are usually entered into as part of a commercial arrangement. The individual is agreeing to restrictions in return for becoming or remaining or an owner of the business and benefiting from its value. That fundamentally changes how the restrictions are viewed. Because of this, courts are generally more willing to uphold shareholder covenants, even where there's a wider scope. So, for example, you're more likely to see and enforce restrictions that last for a longer period. As Alice mentioned earlier, they're looking at maybe 3 months, whereas in a shareholders agreement, we've seen 2 years, you can go to 3. So it's just really looking at that period and seeing what's reasonable. Cover a broader geographic area, or impose wider limits on competitive activity. So provided all of these are still linked to the value of protecting the value of the business, courts will accept them. In terms of the types of restrictions themselves, they look no different to what you'd find in an employment contract. So you'll have your non-compete, your non-solicit, non-dealing, and confidentiality. But the key difference is that in a shareholders agreement, they are often drafted more robustly and with less of a tight limitations you might expect in an employment context. Another important distinction is when these restrictions are triggered. So with employment covenants, the starting point is usually termination of employment, but with shareholder covenants, the trigger is often linked to ceasing to be a shareholder, or sometimes even to transferring shares. That means the timing can be quite different, and if not thought through carefully, you can end up with gaps or overlaps in protection. There is also a close interaction between restricted covenants and good leaver and bad leaver provisions. In many cases, these concepts are designed to work together. So, for instance, someone classed as a bad leaver may not only receive less favourable value for their shares, but may also be more firmly constrained by restricted provisions. Then, taken together, these mechanisms are intended to control behaviour on exit and protect the business from competitive risk. I've seen in articles before that when an employee shareholder leaves, that they might keep some of their consideration for their shares behind for a year whilst those restricted covenants play out, just so that they can then use that consideration in the event that there is a breach, and that just protects the company rather than having to go after the exiting shareholder. Actually, the exiting shareholder has to go after them for the money that they've kept. So there's different ways of protecting your business under restricted covenants in shareholders agreements. So in practice, if the shareholder covenants are weak or missing, you may find yourself relying on employment restrictions that are far more vulnerable or challenging, particularly with a senior individual who has deep knowledge of the business. From a practical perspective, shareholder restricted covenants are often your strongest form of protection in this type of exit scenario. They can provide real leverage in negotiations and act as a meaningful deterrent against competition or disruption. But that's only the case if they're thought through carefully and properly drafted at the outset. Ultimately, the key takeaway is this: restricted covenants should not be treated as purely an employment issue in a director or shareholder exit. The real strength of your protection is often it sits in the shareholder documentation itself. So to conclude, exiting a shareholder individual who is both a director and shareholder is rarely a straightforward exercise. The risks tend to rise where there is misalignment between corporate documents, where legal provisions are unclear or poorly drafted, where the mechanics of shares and options are not properly understood, and where restricted covenants do not stand up to scrutiny. If there is one overarching message to take away, it is preparation is everything. I'm a Sunderland fan, and Roy Keane, I don't think it's a Roy Keane saying, but Roy Keane said, fail to prepare, prepare to fail. So there you go. If your documents are properly drafted, aligned, and kept under regular review, you place yourself in a much stronger position. You retain control over the process, reduce the scope of disputes, and significantly improve the chances of achieving a smooth and commercially sensible exit.
Well, thank you, Emily and Alice. That was really insightful. Lots to take away and to consider. In summary, I guess we all can see that senior exit are a people employment side, of course, but it's also a business risk, a broader business risk, a reputational issue. And Alice ran through, the reputational risks at courts and tribunals. And the best outcomes depend on early planning. So Alice and Emily have expertly taken us through those key considerations, and we hope you can take those away today. The priorities are clearly across the board to ensure the contractual documentation is robust, from your service agreements to your shareholding terms. Review those terms and understand your good and your bad leaver provisions. Manage your confidentiality provisions and data very carefully. A great tip is to have your senior exit protocol. You don't want to be reacting and trying to gather all this at the end when timing is key. Document all your decisions. So if there are signs of a team move, breach of confidentiality, or some similar risk, take legal advice, act. Those first 48 hours are critical, as well as your planning ahead. Where appropriate, consider whether a settlement route is the right approach. And the message from part one was that preparation is key, and that is equally, if not even more important in part two. So we've covered a lot of ground in both sessions, and so I would encourage you to treat part one and part two as a complete toolkit. Part one covering the foundations for all your staff, all levels of employee, and how to manage those well. And today's session has focused on the thorny additional protections and complexities with senior employees and those director and shareholder disputes. So shortly after today's session, you'll receive a follow-up email from us. It'll include a link to the webinar recording so you can revisit the key points in your own time. We'll also include a really practical senior exit risk map, effectively a checklist that sits along and builds upon the part one checklist. And together, those resources should give you a nice point of contact and should help you identify what needs tightening now. From contracts and probation processes through to the senior exit planning and your internal protocols. So if today's discussion has highlighted any gaps in your own documentation or processes, please do get in touch. We can support with reviewing and refreshing contracts and service agreements, advising on senior exit strategy, and delivering training for managers and leadership teams so that everyone understands the risks and the steps to take. And we've talked a lot today about business risk, and the stakes are becoming increasingly higher, especially around these senior exits. So you therefore may wish to consider employment tribunal insurance. It can help protect your business against the cost of employment disputes, which can quickly become expensive and time consuming, particularly with the removal of the compensatory cap and the impact that may have on your higher earners on bonus disputes. We will circulate some information on this, and please do contact us as we'd be happy to help you and provide any further information that you might have. And so we've got about 10 minutes to look at questions. I've noticed that there are a few in the Q&A chat, which is fantastic. So please do put in any further questions that you've got, but we will turn to the questions that are already in there. And I think, well, the first one I'll just address quickly. So slides for part one, are they available? If you weren't able to attend, if you did sign up, you should have a link to the recording and the slides. If you haven't signed up and can't find that link, please do contact us and we'll be able to share the slides and the resources with you. So just drop us a line. If we look at the second one, maybe that's a good one for Alice. If a senior employee leaves during live tribunal proceedings and the employer doesn't take a witness statement before they go, okay, and there could be a number of reasons, I guess, why you haven't taken the witness statement. We don't know the proceedings are happening. We don't know the issues in dispute. We just haven't taken the witness statement. Can the tribunal draw adverse inferences from that omission?
So what you're saying there is that tribunal, the senior employee has left and another employee has brought proceedings. Is that correct?
I think that's so there must be a live claim. My understanding is there must be a live claim and they haven't taken a witness statement. So can the tribunal draw an adverse inference from the fact we haven't taken that witness statement?
Well, not necessarily. It really depends on how far the proceedings are along when the senior employee exited. I mean, obviously it's better to do so, but even if you had taken a witness statement, if that individual isn't there to give evidence in the tribunal itself, that could potentially cause problems for you. You can subpoena or basically make an application to the employment tribunal to essentially force that individual to give evidence if they're refusing to do so. Um, yeah, I think obviously it's helpful if you can take a witness statement earlier. It'll definitely help, but really, unless you have it, if that individual doesn't want to turn up to give evidence in the employment tribunal, unless you can get an application to force them to do so, in that case, if the application doesn't succeed, then the tribunal's not going to say, well, they're going to draw adverse inferences from that because they're the ones that individual's not supposed to turn up. So yeah, it's tricky. It sort of depends on where in the process everything is coming on, but witness statements really needs the other side really need to have the opportunity to cross-examine that witness in employment tribunal proceedings.
Yes, and I guess it's the importance of the evidence of that individual. Is it
Yeah,
a key decision maker? If the key decision maker isn't able to turn up and give evidence that day, well, it might be hard. The evidence before you might only be what the employee is alleging, perhaps, and you're not able
yeah,
to. So it depends on the relevance of that witness too. And equally, and I think you've made the point is if you order a witness to turn up, that might not always be ideal. We don't know what that witness might say, and the 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 last thing that an employer wants is an unhelpful
as a
witness.
reluctant witness. Yes, exactly. So if you are having to force them to turn up to give evidence, you don't know what they're going to say, and if they've had a bad exit from the company, then you definitely don't want them turning up. So yeah, it's a difficult one.
Yeah, who you call and how you go about it is definitely case by case, and it's strategic often. So it'd be wise to take some advice on what you do around that.
Also, the other thing is to add is in some employment contracts you can add a clause that says, if you leave, that you agree to, if there are any proceedings that we need your help with, you can include clauses in employment contracts to deal with that situation as well. Something to think of.
Absolutely. And it might just follow, just to conclude around witnesses and ET proceedings. There's a question, can an employer take steps before someone from SLT leaves to limit what they say in live ET proceedings? My answer would be no, because you are, regardless of what's happened, whether there's a settlement agreement, anything, you give evidence on oath and you have to give the whole truth. And so there's no limitation or prohibition around that. And anything to add, Alice?
No, just unusually in the settlement agreement it says if there will be a clause that says nothing can stop you from giving evidence if required to do so by law, or in the tribunal because you are under oath and you can't be gagged there.
Okay, I think we've got some more information about that one. Just the preliminary hearings next week. Final hearing is in October. And you didn't interview him during the grievance as he was a witness. So we've got a witness in a grievance process and
Okay, rather than a decision maker.
mm-hmm.
Yeah. Well, yeah, again, if they're not going to, it depends how, even if they're not the decision maker, they may have, very helpful evidence as a witness. But if the only way you can get them into the employment tribunal is by getting an application from the employment tribunal to do so, I think you need to be careful about that. And I think the employment tribunals understand that employees leave, don't they? They know that employees leave, and you can't always make someone give evidence. So yeah, it's not unusual for
Yeah,
that to
and there
happen.
presumably will be documentary evidence.
Yeah,
There's going to be
exactly.
something in the bundle that might well
Exactly.
help tell the story.
And yeah,
Uh,
exactly. Not fatal to a claim to defence.
yeah. And then I think, Emily, there's a question that may be suited to you. What steps should we take if the director contract does not include a resignation obligation on termination?
So if we're talking about termination is about to happen, and then you look at the contract and realise, oh, we don't have a resignation in there, then as I mentioned, you can go, well, first of all, look at the Articles of Association and Shareholders Agreement, because shareholders might have a right to terminate to change directors anyway, by giving notice. So that's one thing. If there aren't those provisions in the articles or shareholders agreement, then I would use the statutory route, so the section 168, and that would be giving them notice, having a 28 days notice period, and then removing them that way. That's really the only way. If you're looking at your contracts now and think, oh gosh, we haven't got one in there, let's put one in, then you can just do a variation to the contract itself. And we're always here to help you if you need assistance in that.
Thanks, Emily. They were all the questions that we had, but if you do have any others, if you would like to follow up, please do email us, and we'll do our best to come back to you to guide you as best that we can. And obviously, we will be sharing the checklist and the resources, so they might raise some clarification and questions. So please do contact us. So moving on, just to cover off, as an organisation with many lawyers, it would be remiss of us not to draw your attention to our legal disclaimer. Obviously, laws, in particular employment laws, are often changing, changing quickly. We've got a lot of change in the employment world. And so our advice is up to date as of today. And to conclude, on this sunny afternoon, we'd really appreciate your feedback on today's webinar. Please do take a moment to complete our short feedback form on the email that you'll receive and share your thoughts. Let us know if there's anything in particular that you would like us to cover in the future, any specific employment, commercial, or other services that you'd like us to cover. And for now, we just really like to thank you for being part of today's session. Thank you for the excellent questions. Reach out to us directly for any further queries, and any thoughts on part 1 or part 2. We look forward to staying connected with you and to seeing you at a future webinar or an event, and have a great afternoon and week ahead. Thank you very much.
Thanks all.